Good afternoon, and we're glad to have you join us on Law and You this beautiful Monday afternoon on Independent Television. We're broadcasting live from Benin City, Nigeria. This is Law and You. I'm Ugi Yagumofwegwe. On the program today, the focus will be on criminal justice administration in Nigeria. We're looking at the core elements of that instrument. I'm joined by a very brilliant lawyer, Barrister Justin Nwaifu. Many thanks for coming on the program. Thank you very much. It's been a while you've been here. I think this is an opportunity to take a second look at some issues that have to do with law. But I think we want to start off by looking at what exactly it means when we talk about the criminal justice administration.
Okay. Criminal justice administration is governed first by the Constitution of Nigeria. The Constitution provides that every Nigerian is entitled to be protected with his fundamental human rights. So when you're looking at criminal justice administration, you first of all look at criminal justice, what it means. It means that anybody that is associated with crime or whatsoever is protected under the law. His rights are guaranteed. But to what extent is determined by the Criminal Justice Administration, which is governed by the law 2015 Criminal Justice Act. It means that if an accused person or a suspect is arrested by police, there's a time frame with which it should be tried. Is entitled to bail. It also means that you cannot subject him to inhuman treatment,
regardless of the enormity of the crime.
Yes, because first of all, the issue of his criminality is not in question anymore.
Okay, that's been established.
Yes, what is in question is he's going to, once he's found guilty, he's going to be punished for it appropriately. But before that, he's entitled to fair hearing. His liberty must not be in jeopardy. So the criminal justice system under the Constitution is provided for with that in the 2015 ACAJA, which is Administration of Criminal Justice Act.
2015?
Yeah, 2015.
I need to bump in on you for obvious reasons. You've painted a very beautiful scenario with regards to the ACAJ. But let's look at its application. Because it is one thing for you to have it all laid out with regards to the instrument itself. But let's look at how it's applied real time.
Okay. The application is easy.
Okay.
But the truth about application in Nigeria boils down to people that are affected in the first instance.
Okay.
I give you an example. An average person who is in police custody wants to shortchange law. You want to shortchange the government in punishment by offering bribe to police so that the punishment is entitled to in that a crime for which he has been arrested, he does not get it. So the application of criminal justice system in this country is there. It has always been there. But we, the people who are affected, want to shy away from it, because we don't want to be punished for our acts of transgression against the law. We always want shortcuts. But the law is that whether you want a shortcut or not, you are entitled to certain rights under the law to be protected from brutalization. If police arrest you for certain crime, you are entitled not to be. You are entitled to bail at the onset. You are entitled not to be locked up indefinitely.
You mentioned how that, as an accused person, for instance, you are entitled not to be locked up indefinitely.
Yes.
Ironically, we've seen cases, maybe many more than we can count on our fingers,
yes,
of how that people have been arrested and then locked up indefinitely.
Yes.
What is the implication of that?
The implication is that it clogs the prison systems, where you have too many awaiting trial.
Okay.
But
in some cases, some persons have not even been taken out of the police cells.
Yes.
Exactly. Then the police say, we are investigating. And of course, it's a key element in the whole prosecutorial process that an accused person is investigated.
Okay.
Exactly.
Yeah.
So it's like neither here nor there, because on the one hand, police say we're investigating, and then a lawyer like yourself says you can't detain this man for longer than 24 or 48 hours. How do we strike a balance between both scenarios?
Ordinarily, there are categories of offenses for which somebody may not be entitled to bail.
So there is the issue of severity.
Yes, that is almost immediately. It's not that you are not entitled to bail. You are always entitled to bail for any offense whatsoever. But for capital offenses, police will need more time to investigate. But for non-capital offenses, maybe misdemeanor and all that, the law is that the person is entitled to bail almost immediately, within 24 hours, if it's proven. But where police are adamant, the person through his lawyer have a right to apply to a magistrate to seek bail. That's what the present law, the 2015 ACAJ, provides. You are entitled to bail. If the police is denying you bail, apply to a magistrate, because the law also provides that a magistrate has a right to go to the police station to ascertain the number of people detained at a given time and ask why so many people are being detained, why they are not being tried or sent to court for trial. And
the magistrate is required to do that on a case-by-case basis.
Yes, the chief magistrate.
But is that what we have happening?
That's what the law provides. So if a chief magistrate does not perform his duty,
that's another issue altogether.
It's another issue altogether. That's what the law provides as of now. The 2015 Criminal Justice Act provides that a chief magistrate of a state has a right, actually mandates the chief magistrate to once in a while go to the prison, the police stations, to ascertain and take inventory of people that are detained and find out those that are being detained beyond, especially those that have misdemeanors, minor offenses,
maybe civil issues.
Yes, small minor offenses that are not serious felons. They have a right to be bailed. Where police is lacking in their duty, the chief magistrate can do the needful.
In the last few minutes, you've made continuous reference to the ACAJ 2015.
Yes.
It makes me want to ask, how were we doing with regards to administration of criminal justice prior to 2015?
Okay. Before then, we had two ununified laws governing criminal justice administration in Nigeria. One was for the North, one was for the South. The South was governed by CPA, Criminal Procedure Act. Then for the North, a Criminal Procedure Code. Both were offshoot of our colonial masters. They were given to us by our colonial masters. They were not unified. It didn't unify. It gave police, as it were, certain powers that tend to degrade citizens of the country. So, as at the time of coming of ACAJ, the two laws or the two acts were repealed, as it were now. So they are no longer in existence. The extant law now governing administration of criminal justice in this country is the ACAJ 2015, as enacted in May.
Okay, May of
2015.
Yes. So we've had it running for 2 years.
Yes.
But tell me something about this. They say the wheel of justice turns slow.
Okay.
Why do we have that, really? Because people want to get justice as quickly as possible.
Yeah.
Of course, that's the human factor, obviously. However, the wheel of justice, we're told, turns very, very slow. Is there something that could be done to speed it up, at least in some cases?
I will still take you back to the current law,
yes,
the ACAJ. The ACAJ has put in so many apparatuses to make sure that anybody taken in by the police or in courts have speedy or expedited hearing.
Okay.
First of all, people are not supposed to be remanded in custody for more than 14 days without trial.
Okay.
If it happens that the trial cannot be carried out within 14 days, another 14 days is extended to it.
That's, well, 28 days.
28 days. But on the whole, it should not go beyond 56 days before somebody is taken to trial. And where it is become impossible for that person to be taken to trial, the chief judge can, in an interaction with the AG, that's the Attorney General, seek that that person be released unconditionally.
Unconditionally?
If the person cannot be tried or prosecuted by police
within 56
days, yes. And the person is in remand. The person can, ought to be, released unconditionally. That's what the law states. So the essence of this is to remove a lot of awaiting trials. Awaiting trials form bulk of people in prison, which is congesting the prison system in this country. So the AG has put in so many things in place.
Like measures, you mean?
Yes, measures, yes, now. To make sure that the justice is accelerated. Some of them are issues in suspended sentences.
Okay.
A judge can suspend a sentence if the person affected is of good behavior, if the crime is not a capital crime. There is issue of parole. A person can be put on parole. A person can be put on probation. There's also the issue of plea bargain. When the prosecutor finds out that the person in question, that's a suspect or an accused person, is not in any way going to destroy the trial, and the offense is light, it can enter into a plea bargain to be able to get a lesser sentence, as long as the suspect or the accused person gets cooperation to be able to bring in every other person that is involved in the crime, so that they can be charged. But he will not get a lesser sentence
for cooperating.
For cooperating fully with prosecution. So these are the measures put in place by the ACAJ to ensure that justice is not delayed, so that the wheel of trials in this country can run fast.
Can speed up faster.
Yes, so that issues in awaiting trials are reduced.
We're going to talk about parole and the issue of probation just after this break. Then we'll talk about why Nigerians, we'll also look at the issue you raised when we talked off camera, when you talked about how that the justice system is cumbersome. We'll look at all that after the short break.
The DPO comes in the morning and says, "What are you doing at the police station? What are you doing here? What are you doing there?" And you say, "I was arrested." "Why? Who arrested you?" "John arrested you." "Call me John. Why did you arrest this man?" If he cannot give an account to the DPO why he's arresting, the DPO asks you to go.
If I point a gun at someone, he gets frightened. It is battery, even though no physical injury has been suffered.
Citizen of a country, you have all your fundamental rights intact, and nobody, including the police, can subject you to extortion and inhuman treatment.
We're glad to have you stay with us on the program Law and You. Let's expand the conversation a bit further, right? Let's talk about the options, if you will, of probation and parole. How do they work?
A parole or a parolee is somebody who is already been sentenced.
Okay. Already has been sentenced?
Yes. Been sentenced. But maybe to a very long term in jail. In order not to have the system choked up, that's more prisoners in the cell, because in Nigeria the prisons are overcrowded.
Okay, so the goal is to decongest.
Is to decongest. And this particular accused person has been of good behavior, because the essence of the present ACAJ is also reformative and restorative.
Okay, which were not the issues before now.
Before now, yes. So, if this accused person has spent half of the term in jail, he is entitled to parole under the new system. If he is of good behavior, he has taken up reformative remedial activities in the prison that can refine him when he comes back to society, he will be of good behavior, will not go back to the crime, he will not be of use to society, he can apply for parole. That is, his jail term will be cut into half and is brought to society, where if we have a social service, is supposed to watch him.
Okay.
Because
a
social worker, because the shortcoming of this present ACAJ is that we don't have a social service system. But the issue of parole is hinged on the registrar of courts for him to appoint people who will oversee parolees, people on parole.
Is that the case? Do we have those, that kind of
The
arrangements?
registrar is empowered
Okay.
to make those people available by the new law.
Okay.
But naturally, it's supposed to be with the social service arm of government. That means from the Ministry of Social Services.
So it should be an institutional arrangement?
Yes, by itself. Because if you now tell the registrar to deal with that, you are going to give him more work to do as a registrar of court.
Okay.
So he's the one to actually have people to supervise this parole, because they will be in society. They will have records to show that from certain period, go back to report to your parole officer, because there should be a parole officer. The parole officer now will now report to the registrar and onward to the chief judge, as the case may be.
Let's look at probation. How does it work with probation?
Probation and suspended sentences and community service go together. If somebody commits a minor crime, actually, there is no need for us to
send him to jail
or mix him up with hardened criminals. You can put him on probation or subject him to community service. By community service, you are making him useful to society. You can tell him, go and clean a sewer. It depends on how they designate it, or how government will designate that. If he's proven to be of good behavior, the charge can be dropped
altogether.
Yes, because it has to deal with minor offenses, not capital offenses. Maybe it's misdemeanor, light assault, and all that.
In the course of our conversation earlier, you had alluded to the cumbersome nature of the court system, because you can't take away the court from this conversation.
No.
I don't want to ask you how we got there, but what could be done to onboarding the courts, as it were?
The truth of the matter is that we need to expand our judiciary by way of personnel, by way of technology, and by way of total modernization. As it were, the judges still use Braille, and that reduces the amount of work they do. You can't have somebody listening at the same time writing, but that's what judges do. That brings about the cumbersome nature of their work. But if he was just there to listen to evidences, and somebody is taking down what the witness is saying, the judge will have more time to evaluate whatever evidences they are giving. But right now, in all our courts, we still use the old system where the judge, the magistrate, the president of court, as it were, use manual writing. They use hand to write.
So they're doing two things at the same time. They're listening and they're writing.
And writing. And even trying to show, maybe if you are not giving a good evidence, they'll try to correct you and all that. That's not supposed to be their job. Their own is to listen to you and evaluate your evidence. But now he's encumbered with writing and listening at the same time, which are two difficult things to do. So for now, that is the place we find ourselves.
I spoke with the immediate past Attorney General of the States, and that was in late 2015. We talked about a whole lot of issues, including these issues being raised right now. And one of the things he hammered on was the fact that courts need to be automated. Obviously, that's in correlation with what you've said.
Yes.
But again, isn't that a pointer that there's so much to be done within the judicial system, especially in the light of the ACAJ 2015.
2015. Of course, the essence of the ACAJ now is to expand.
To expand.
Yes. One aspect of that is that before now, if police were taking confessions, it was in writing. But the ACAJ now provides that when police are taking confessions, they can take audio or visual.
Okay.
So as to stymie what we know as a trial within trials. Because more often than not, if a confession was taken, an accused person can say he was induced to make that confession. And once that issue is raised in court, the whole trial is held up by what is called a trial within trial, which means they will go on appeal to find out so that issues of those breakages or those intermitations will not occur anymore, so that trials can flow very fast. So it now boils down to automation. Once police have those facilities, or even courts have those facilities, they are automated, court data, they are upgraded, you can fall back on all those.
As we wrap it up on the discussion, let's look at the fact that Nigerians, of course, as you know, are generally reluctant to approach the courts, even where their rights have evidently been trampled upon. What should the average Nigerian know about how the ACAJ works?
The ACAJ is treating in their best interest.
Okay.
They have to know that. It's a piece of document that protects every Nigerian's fundamental human right. And the ACAJ has done its best now to expedite how trials are carried out. Bulk of the elements of the ACAJ is speedy trial. So every Nigerian should not be reluctant to approach court for them to seek redress in whatever matter. Because the extant law now in this country is the 2015 ACAJ.
Okay.
Which has done its best to showing that trials has to be speedy by all its elements. The ACAJ is made up of 495 sections, broken into 49 parts. It has done its best in every way to ensure that trials are speedy, civil liberties are not tampered with, human rights, are met, they are not infringed upon. It even went as far as showing that victims in a criminal offense can be awarded a cost. That is, it can be compensated. Unlike in the old regime, where if you commit a crime against somebody, all the person gains is that the criminal goes to jail. But now, with the ACAJ, a victim, a court can make the accused person compensate the victim for whatever hurt they suffered.
In addition to probably going to jail?
Jail, yes.
Okay.
Yes, the cost of medical bills and all that. The court has a right to make the accused person pay once he's found guilty. Okay,
so we hope that in the days, weeks, months, and years ahead, members of the public, will
can embrace it.
Embrace it altogether, and then, of course, they'll need services of lawyers like
lawyers,
yourself.
Of course.
So that means more business for lawyers.
The one element there too is that prosecutions now have to be done by lawyers.
By lawyers, okay.
Yes.
Okay, and we need to establish that.
Yes. Prosecutions across courts now for criminal situations has to be done by lawyers. Because before now, police were in charge of prosecution, which was maiming, good justice. So
all that has changed.
Yeah, the ACAJ provides now that lawyers are the ones government ought to put as prosecutors in criminal cases across the country.
And I hope that all that is made clear. Thank you so much, Barrister Justin Owaifo, for coming on the program.
You're welcome. Thank you very much for the opportunity.
We've been talking about the administration, I should say, of criminal justice in Nigeria, and of course the core elements of that piece of document, which of course every Nigerian should actually grab and of course take advantage of. And that'll be it for the program this week. I'm Uyi Agumofwegbe. Many thanks for watching. Enjoy the rest of your Monday.